Whereas the DOJ attorneys considered even the suggestion of seizing classified information from President Clinton to be extraordinary. Wait a minute. You're going to say we're going to go seize classified documents from Clinton? Are you out of your freaking mind? Prior restraints on someone's speech, muzzling somebody before they can even open their mouths, are the most serious and the least tolerable infringements on our First Amendment rights. It's a prior restraint. You're gagged before you can speak. Joe Biden was locked and loaded and ready to take me out and put my family in danger. Jack Smith is now on his heels, facing another filing from Trump saying, Jack, you cannot gag me. We know you're trying to cover up your deadly force shenanigans when you raided Mar-a-Lago, but you're not allowed to gag the president from talking about what you did raiding his private residence. So Trump submitted this saying that the entire attempt to silence Trump in the middle of an election season is unconstitutional. It's a nice filing. West Palm Beach Division, Southern District of Florida. We know this is Judge Eileen Cannon presiding. This is Trump's opposition to the motion for a gag that's come out from Jack Smith. Jack wants Trump silenced because Trump said they were trying to kill him. And the FBI said, nuh-uh, we weren't trying to kill you, but we could have if we needed to. So here is what they're asking for. They say, all right, listen, Judge Cannon, not only have they raided us, now they're trying to shut us up from talking about the raid. This is ridiculous. President Trump respectfully submits this opposition, Your Honor, to Jack Smith's motion trying to gag the president. Now, in Jack Smith's most recent shocking display of overreach and disregard for the Constitution, which we happen to love here, Jack's office now asks Cannon, the judge, to enter an unconstitutional gag order as one of the release conditions over the leading candidate in the 2024 presidential election. Now, like Alvin Bragg from New York, Smith, Jack, now seeks to restrict Trump's campaign speech right as the first presidential debate approaches at the end of the month. Jack's motion goes even one step further, and now his efforts are trying to interfere with this 2024 election, and he's trying to help Joe Biden by seeking improper restrictions on Trump's core protected speech that would continue through the RNC in July, and thereafter until this case is dismissed for one of the more myriad reasons we've already identified. This case is crap. Now, fundamentally, Your Honor, Judge Cannon, the motion from Jack is based on the fact that President Trump criticized a Mar-a-Lago raid based on evidence from publicly filed motions in this case. So he's not breaking classified or other secretive sealed information, Your Honor. We're just reading the warrants. And he's allowed to talk about this as part of his constitutionally protected campaign speech. Part of running for president is to fix the broken institutions in this country. One of the most broken, in our opinion, if not the biggest one, is the justice system, the Justice Department. There is no country if you have no law, and there is no law if you have no justice. So in a manner that someone in the government disagreed with and does not like. So he's allowed to criticize the DOJ. Now, the office chose this cynical litigation strategy just one day after concluding a series of untimely disclosures where they told the defense, oh, by the way, here's our policies, here's this other stuff. They revealed in this new disclosure, new discovery, extremely problematic features of the raid. Spoliation of evidence. It was spoiled. The exculpatory material, evidence that would tend to show Trump is innocent, has been ruined, spoiled by the FBI themselves. What is that? That's the shifting of the documents all over the place. There's also discovery violations by the same FBI team in connection with the same unlawful search. So they've tainted everything. Now, Jack's office, to you, Judge Cannon, where he's begging you for a gag order over Trump, is egregiously lacking in any legal and evidentiary support. Now, pursuant to your sealing orders, Judge, no FBI agent who participated in the raid has been publicly identified in a court filing or any commentary by Trump. So this case, you entered a protective order. We've been abiding by it. Now, that is almost certainly why nearly 3 weeks after the most recent Truth Social post cited by Jack, they have not submitted to this court any evidence of any threats or harassment resulting from Trump's protected speech. There have been no problems. Not a single FBI agent who participated in the raid submitted an affidavit or even an argument claiming that President Trump's remarks put them at risk. So the gag order modification is also vague and lacking in sufficient enforcement criteria. So it's just going to gag all of Trump's speech. His broad protected speech, they're trying to chill it. Now, as a result, the requested release condition would place Smith, Jack, and his colleagues in a position to seek Trump's arrest and temporary detention anytime he said something they disagreed with, just like Alvin Bragg wanted to do. And they brought Trump in there during that trial and held him in contempt 10 times, including but not limited to statements on the debate stage. So what happens if Trump says the FBI tried to raid my residence and rig me? They tried to take me out, which they did. It's in the policy. The campaign trail on social media, potentially even including communications by Trump's campaign staff. Trump has to be gagged. So straining credulity, Judge Cannon. Jack's office, they even suggest that that statements by people like Steve Bannon, okay, could lead to Trump's pretrial detention at the height of him running for president. So not only is Trump gagged, there's a message relayed by a third party like Steve Bannon, who they're also throwing in prison. That's enough to throw Trump in prison too. What kind of country is this? For all these reasons, the motion is a naked effort to impose totalitarian censorship of core political speech under a threat of incarceration in a clear attempt to silence Trump's arguments to the American people about the outrageous nature of this investigation and the prosecution in the first place. Neither the Bail Reform Act nor the First Amendment would ever permit such a result, and so therefore, Judge Cannon, you should deny Jack's insane motion. Here's the background, Your Honor. As you know, on August 8th, 2022, we go back 2 years, the FBI carried out an unprecedented raid targeting Trump's residence at his family's home and his office in Mar-a-Lago. Never happened before. They broke American history and the precedent against doing this against political opponents. They did it, not Trump. Whereas the DOJ attorneys considered even the suggestion of seizing classified information from President Clinton to be extraordinary. Wait a minute. You're going to say we're going to go seize classified documents from Clinton? Are you out of your freaking mind? That would be extraordinary, okay? That would be unfounded, they said in 2012. But now, in 2019, 2000 and whatever this was, 22, the DOJ leadership frankly did not give a damn about the optics, their words, not ours, of Mar-a-Lago a decade later. So Clinton, you wouldn't even think about it. He's their hero. He's their savior. Yeah, I don't even give a damn about the optics. Frankly, I don't care because these people are monsters. Indeed, the Attorney General proudly notified the public that he, quote, personally approved the raid. Merrick Garland's very excited. I had to save democracy. Now, during the raid, Judge Cannon, FBI agents that were deployed to ransack rooms for which there was no plausible argument that any evidence might be found. They went into the bedroom suites of First Lady Melania and one of President Trump's sons, as well as a gym and a kitchen, which makes your skin crawl. Did they have any evidence? They had Secret Service footage. They had CCTV footage, rather. They had witnesses. Did anybody say it went into Melania's bedroom? Was she putting classified documents in her closet? No, didn't find anything. There were no conceivable safety risks associated with the raid in light of the existing security at Mar-a-Lago, which is already undertaken by Secret Service and other security. Nevertheless, in connection with this unprecedented violation of a former commander-in-chief's home, a duly elected president of this country, the operations order relating to the raid indicates that the FBI elected to apply its use of deadly force policy right there. Now, I keep hearing from many people that, well, it's just standard, okay? It's in every it's in every raid. I don't care. This is not every raid. This is the president. This is a person with Secret Service protection. This was somebody that was that was elected by half the country, won the Electoral College. It's not a regular drug raid, so you don't use the same things. And if it's in there, if there is a use of deadly force policy, even if it says you can't use it unless, that unless is your license. Oh, unless this happens, then I have a license to use it. Got it. So there is a use of deadly force policy in there, and they were just prognosticating that Trump was not going to be there. Their eyes on him, traveling around like a drug dealer, but he could have been there, or the Secret Service could have said, you're not coming in here. This is our jurisdiction. Now, as a result, DOJ authorized FBI agents that had standard issue weapons and ammo. Why did they have those things if they were not going to use them? They penetrated Mar-a-Lago in a manner that was inconceivable to DOJ attorneys responsible for investigating and litigating with the Clintons. Only recently did Jack Smith's office disclose that the agents destroyed exculpatory evidence that was favorable to Trump's defense during the process, after repeatedly insisting that to Trump and this court that the materials taken in the boxes during the raid were in the exact same condition that they were when they were seized. Not true. You want to go in, okay, when your driver picks up your DoorDash order, it's sealed, it's not manipulated. When you transport it back to your home to eat it, it's sealed and not manipulated. If you open it up and stir everything around, now you've got questions about the taint of that delivery. Same thing happened here. They went, they picked up the boxes. By the time they got back to the FBI, they're not the same boxes. So if Trump had any material in there that might exonerate him, like the sequencing of the documents when stuff went in there, so we could draw a timeline to say, no, Trump had no knowledge of anything that came in after this date, or these were all old documents. To go to the mens rea, the element of the offense, you can't do that. So he cannot defend himself because the FBI manipulated the documents. And then when Trump says, oh, you also came in plain clothes to raid our residence, searching locations, there were no documents at all, to gather paperwork. Now, Trump was arraigned just over a year ago on June 13th, and they released him on his own recognizance, as we know. Now, there was no suggestion at the arraignment that Trump was any flight risk or danger. Trump's personal recognizance bond is subject to the standard condition that it doesn't violate the law, and a special condition over Trump's release is that he refrained from communicating with fact witnesses on the list, except through counsel. And then the court sealed some stuff. Now, Jack's office has not been shy about making unsupported and incorrect claims about risks to witness safety. Everybody is at risk. Trump just crosses the street and half the jurors die. Now, nevertheless, the court has devoted substantial resources and paid meticulous attention to Jack's concerns. And Trump has not stood in the way of sealing this stuff, supported by non-speculative evidence of actual safety risks. And pursuant to the court's rulings, the names of the FBI witnesses who participated in the raids have been redacted from all public filings, and so no one's talking about them, Jack. But we have very serious protections for political speech in this country. Prior restraints on someone's speech, muzzling somebody before they can even open their mouths, are the most serious and the least tolerable infringements on our First Amendment rights. It's a prior restraint. You're gagged before you can speak. Such restraints are one of the most extraordinary remedies known in our law. They are accorded the most exacting scrutiny. So if you have a prior restraint, we put that under a microscope, man. We look at it so hard, 100x magnification, 1000x, maximum magnification, Scotty. This is so because the loss of First Amendment freedoms, even for minimal periods of time, unquestionably constitutes irreparable injury. U.S. Supreme Court case from 2020, which is basically gone now, right? First Amendment, give me a break. Everybody's silenced all over the place, including the leading candidate for president. The First Amendment protects a significant amount of verbal criticism and challenge directed at police officers, even they said in 2020 SCOTUS. Speech is often provocative and challenging, but it is nevertheless protected against censorship or punishment unless shown to likely produce a clear and present danger of a serious substantive evil that rises far above public inconvenience, annoyance, and unrest. Another Supreme Court case, 1987. Now, no form of speech is entitled to greater constitutional protection than core political speech. One of those things that's political is petitioning your government for a redress of grievances. Saying the FBI are a bunch of corrupt maniacs who murder people. Saying the DOJ prosecutes the innocent. Whatever you want. You're allowed to say those things. Or you should have. You should be. I don't know if that's really the case anymore. We'll see if the feds show up here in a few minutes. But speech on matters of public concern is at the heart of the First Amendment's protections. That's why we have it. That's because speech concerning public affairs is more than self-expression. It is the essence of self-government. We cannot have a government if we can't speak to be a part of it. That's why it's the First Amendment, not the Seventh. Thus, the Supreme Court has never allowed the government to prohibit candidates ever from communicating relevant information to voters during an election. Never happened. Has already happened many times, though. This year, Chutkan did it, Engoron did it, Bragg did it with Merchan, and now Jack Smith's trying to do it. Moreover, freedom of speech presupposes a willing speaker. But where a speaker exists, as is the case here, the protection afforded is to the communication, to its source, and to its recipients both. This is a point that I'd like to see the right make a lot more. It's violating our right to free speech to not hear from Trump on these issues. Justice system is a key issue for us here. I know for many of you. It's why you're here. That's why we do this work. Now, they give us some discussion. They say, listen, Your Honor, obviously this is ridiculous. Criticism of the government is at the very center of our constitutionally protected area of free speech. Jack's office offers no basis at all for the claim that Trump's protected campaign speech threatens the integrity of the proceedings. How, Jack? Even if substantiated, such a claim would not warrant a modification of these release conditions. Jack offers nothing to support the suggestion that either of those concerns is an issue based on the motion. And moreover, Judge Cannon, this court has already implemented extensive and much less restrictive measures to avoid harassment or other risks here. The name of every agent who participated in this disgusting raid has already been redacted. And in place of those names, there is now a dizzying list of pseudonyms to keep track of. All the feds. Now, accordingly, for the reasons set forth below, the court should deny the motion. First of all, there is no evidence or any justification for a gag order, period. Jack's office has failed to provide actual evidence. They submitted 5 exhibits, but guess what? Not one is from the FBI or other law enforcement that are apparently under attack. And none of them supports their claim regarding the, quote, risk of threats and violence and harassment. We're so scared. Notably, President Trump and the defense are similarly unaware of any hostility, any harassment, any risk of harm directed at any agent involved in this case at all. Let's go through the exhibits, they say. First of all, Judge, they gave you a post of Trump's Truth Social post. Here's what he said. He said it describes the defense litigation's positions regarding the raid. Trump posted on Truth. He talked about the use of the deadly force policy. He said Joe Biden's DOJ, in their illegal and unconstitutional raid of Mar-a-Lago, authorized the FBI to use deadly lethal force. It's true. So they say, okay, yeah, he posted that, Your Honor. That's hardly deceptive and inflammatory, you crazy. The post accurately summarizes aspects of Trump's legal defense, and it contains truthful and accurate characterization of the deadly force force policy that did apply during the raid. It was in your documents. He's just quoting you. Specifically, the policy stated this: law enforcement officers of the Department of Justice may use deadly force only when necessary. So they say, no, that's a limitation on the use of force. They cannot use of force. And you just read it. It says may when necessary. It's right there. Exhibit 2 is May 23rd campaign communications, an email. The email stated it's been revealed through the unsealing of Trump's suppression motion. They say the Biden DOJ was authorized, he wrote this in an email, to use deadly force for their despicable raid in Mar-a-Lago. While President Trump's use of despicable appears to have ruffled someone's feathers. Oh, so that's funny. That is not a basis for the government to violate the First Amendment. In public debate, we say we must tolerate insulting, even outrageous speech, clearly, in order to support adequate breathing space for freedoms protected by the First Amendment. You're allowed to be outrageous. You're allowed to exaggerate. You're allowed to call things despicable and say they were trying to kill me. They were trying to assassinate me. They say, no, we're not. That's the whole point of having free speech. You have an arena of ideas. You get to battle that out. Now, the May 23rd email communication, also marked as Exhibit 2, also stated, Joe Biden was locked and loaded and ready to take me out and put my family in danger, which is just a great sentence. Whoever wrote that, well done at the campaign. Now, the special counsel's office claims this is an example of, quote, deceptive and inflammatory language. Regarding the false charge that the speech is deceptive, they say, well, the Supreme Court has rejected the notion that the government may prohibit speech through a provision that just targets falsity and nothing more. Supreme Court has even said this in Alvarez, 567 U.S. 709, U.S. versus Alvarez, 2012 case, plurality opinion from the court. They said characterizing speech as inflammatory obviously did not deprive the demonstration of its protected character under the Constitution. Now, it's a bedrock principle, fundamental, at the rock bottom, that the government may not prohibit the expression of an idea simply because society finds the idea offensive or disagreeable. U.S. Supreme Court, 1989. Prohibiting that speech because it is the government itself that finds the speech offensive is even more problematic. It's why we have this in the first place. Yes. Oh, the government's offended by something we said? Good. That's the point. What did we say that hurt so bad? I'm going to say it harder now, next time. Exhibit 3, True Social post from President Trump that is substantially similar to Exhibit 1. Like, he said it twice. The principal difference is that in the May 23rd post, President Trump argued that the Secret Service, which is responsible for protecting Trump, his family in Mar-a-Lago, thought that they might be, quote, in the line of fire. Now they say, well, yeah, it's a nice statement. Now, in light of the statements in the operations order that the government drafted, not Trump, that was a plausible concern for President Trump and the Secret Service. So in addition to the deadly force authorization that they authorized, and the FBI's instruction that the participating agents, quote, bring standard issue weapons and ammos to gather paperwork from tables and boxes. You should bring a bottle of water and some comfy shoes because you're hauling boxes around. Sheesh. Not guns and ammo. Who are they going to shoot with their guns and ammo? The president? Yes. The Secret Service? Yes. That's what is there. There's no one else there. Is there a secret cartel there? Is the Taliban hiding in some closet somewhere? It's for Trump and the family, clearly. The operations order included contingency planning steps for the FBI. The FBI would take, should the Secret Service provide resistance, this is quoting from their order, or interference with the FBI timeline or access, there would be contingency plans from Trump. He's pointing this out, that the FBI would have contingency plans if there was pushback. Now, the fact that armed FBI agents raided Mar-a-Lago while planning for potential resistance, and while also saying from well-intentioned and also armed Secret Service personnel created exactly the type of dangerous, volatile, and entirely unnecessary situation that Trump has criticized in his public statements. And moreover, the DOJ frankly did not even give a damn about the optics. But now they seek to threaten Trump with detention for commenting on them. Okay, it's their documents. He's commenting on their paperwork that they filed. It's their raid. Trump can't talk about it. So Exhibit 4 is another post, ex-post by Steve Bannon, who they're also trying to jail, and probably will, we'll see. But they have also orchestrated his jailing to coincide with the election as well. They're trying to shut him up for the next 4 months. So he gets out right before the election. How convenient. They also want Trump gagged. He called the Mar-a-Lago document search an attempted assassination by Joe in support of the troubling suggestion that a third party's protected speech, right? So they attached that post by Bannon, an ex-post attributing to Steve Bannon. They said, see, that should also limit Trump because he's calling it an assassination attempt through third parties. They say in support of this very troubling suggestion that a third party's protected speech could also be the basis for incarcerating Trump via an unconstitutional prior restraint. They just said that Bannon predictably and as he certainly intended, others have amplified Trump's statement. So Trump posted posts it, they amplify it, so they should be penalized. Maybe Trump should be penalized for those amplifications. So relying on similarly flawed reasoning without any evidence at all, Jack's office also seeks to blame Trump for the tragic violence that happened on August 11th at the FBI building. Now, one would hope that the FBI investigated that incident extensively. Who knows? I don't know if there were any J6ers there, so who knows if they even cared. Surely, if there was actual evidence of the type of link to President Trump that Jack is suggesting here, as opposed to bias and conclusory speculation, they would have submitted some actual evidence beyond just two stupid newspaper articles and a dumb footnote, Jack. So you can see Jack is trying to blame the violence on Trump. Well, the FBI got attacked. Only political animus exacerbated by deep arrogance, like the prosecutors have, which is basically the DOJ. I mean, come on, let's be real, would cause a group of prosecutors to make such a false, flawed claim in a belief where their main argument is that Trump has made statements that they believe are deceptive. So they're saying, okay, you call us deceptive? You're saying that Trump was responsible for violence on August 11th at the FBI location because you raided him on the 8th? Is that what you're saying? And there's no evidence of this because presumably they investigated it and they would say, oh, the person who caused that violence was connected to Trump or motivated by Trump, but they've got no evidence of that at all. They're trying to conflate one thing with another and blame Trump for it. Exhibit 5 is another Truth Social post, which is so damaging to them. It's just amazing how these Truth Social posts cause such a ruckus on their end. They can't handle it, so they try to silence you. They're cheaters, bullies, censors, and liars. Trump only serves to illustrate how lacking in support their motion is. Largely duplicative of aspects of other exhibits, the post also says the truth. Trump posted this: Biden's DOJ authorized the use of deadly force against President Trump in the Mar-a-Lago raid. Jack's office wisely limited discussion of this post to a footnote where they expressed outrage. They said, even the day after this motion was publicly filed, Trump continued to post deceptive and inflammatory assertions. Trump's defense says, no. To be clear, as we said shortly after Jack filed the motion in this manner, that the court appropriately characterized as wholly lacking in substance and professional courtesy. Remember, the gag order came on the Friday before Memorial Day weekend, and they didn't even discuss this with Trump. They're supposed to coordinate with the defense to get their sign-off on the motion, and they didn't do that. Now, the office's filing of a frivolous censorship demand without any support for any of these claimed safety risks has, well, they say it has no impact on Trump running for presidency. They say, listen, to repeat, we will not acquiesce in unsupported histrionics from unbiased and reckless prosecutors who have shown no respect for the First Amendment, other constitutional protections, the local rules, and the court's orders. And now, based on these 5 exhibits and these 2 news articles, Judge Cannon, Jack's office has not demonstrated that this gag order is reasonably necessary to assure the safety of anything. And even if the evidentiary showing by Jack's office did pass muster, and it doesn't, the gag order modification would also serve as an unconstitutional and wholly unwarranted prior restraint. Jack's office and their exhibits reflect core political speech, every one of them. Each of them references Joe Biden. Exhibit 2 is a communication, literally it's an email from Trump's campaign. Freedom of speech has its fullest and most urgent application precisely to conduct campaigns. And so these 5 exhibits fall very short of the solidity of evidence that's required here. Nothing rises to a clear and present danger that meets the rules. And also, Exhibit 4, that's talking about Steve Bannon, is also troubling. The logic of Jack's office and the reliance on Bannon's reaction to Trump's publicly filed motion is based on an unlawful heckler's veto theory that Trump's speech may be restricted because his audience might react with some hostility. That is clearly not constitutional. Indeed, a speech burden based on an audience reaction is simply government hostility and intervention in a different guise. Oh, no. We're not going to limit what you can say. We just don't want your audience to get mad about what you're saying and something bad might happen to them. So then you're just gagged. It's a censorship format that's just a slightly more clever. Now, the gag order is also unconstitutionally vague as applied. It ignores all the practical challenges, all the infirmities. They say, who would decide if you impose this, Judge, whether a statement by Trump during the June 27th presidential debate or the Republican National Convention, who would be the judge to decide whether it is a danger to law enforcement? To our knowledge, the probation officer has no interest in taking that on. Hard to blame him. But Jack, however, could seek an arrest warrant or at least temporary detention if he believed Trump crossed his line. Now, the gag order modification is also ambiguous. It lacks in any enforcement criteria, and it's going to invite arbitrary enforcement by Jack, who happens to be a surrogate for Joe Biden, also illegally appointed. Piling modifiers like onto the word danger, they say significant and imminent and foreseeable. It doesn't give us any guidance. They just put in a bunch of words in there. And so now Trump has to have his speech chilled completely so that he doesn't possibly run afoul of the vague rules. this? This is clearly illustrated by the fact that Jack's office believes that their proposition would clearly be violated by the statements deceptively claiming that the agents were trying to eliminate him. Their formulation requires no threats, doesn't require true threats at all. There's nothing in their standard here that would approach an extremely high degree of imminence or anything like that. There would be a massive chilling effect, not only suffered by President Trump, but also us, the American people. The voters, that's us. We have a well-established right to receive information. It's our right to receive information and ideas. How can we be a democratic republic if the people can't even understand what's going on? Because they can't tell us. They won't tell us, including ideas that Biden, Smith, or the prosecution in this team that we think are disgusting, deceptive, disagreeable. If we want to have those opinions that they're deranged thugs and they attempted to assassinate Trump, we're allowed to have that opinion. Now, therefore, the ambiguities, the lack of enforcement criteria, and the resulting chilling effect are a separate basis for denying the motion. And also, this other case, Your Honor, Judge Cannon, doesn't support the gag order either. Contrary to Jack's stupid opinion, the analysis in this other case doesn't add any merit. The D.C. Circuit's opinion is not binding, and to the extent that it authorized prior restraints on Trump's speech, it's unpersuasive. It's plainly distinguishable in any extent. U.S. versus Trump, D.C. Circuit says this motion is based on an alleged non-existent safety concern arising from Trump's speech. That was not even an issue in that other case. There, the D.C. focused on Trump's ability to speak about his criminal trial and the need to protect the criminal trial and its truth-finding function. The D.C. Circuit framed its merits analysis on balancing two things, the right to free speech and the functional of a criminal trial process and its function. Now, and that was obviously Judge Chutkan. It was on the J6 case. Now, as to the First Amendment, the court described political speech as, quote, the lifeblood of American democracy, which is why they're trying to strangle it so badly. The First Amendment is a danger to them because they can't consolidate their power if we can question it and expose them. So they try to strangle the free speech, which in turn strangles our republic. Also allows voters to make informed decisions about those who seek to represent them. Moreover, in the D.C. Circuit's view, speech about judicial proceedings promotes transparency. And so the only compelling government interest that they had for curbing the rights, Trump's rights back then, was the fair administration of justice. And so the Trump panel also rejected an effort to clarify the unconstitutional gag order, talking about targeting and other significant risks. And finally, the D.C. Circuit also imposed a mens rea requirement that is absent from this gag order. This gag only prohibits Trump from speaking about stuff that interfere or the knowledge that some inference is going to result. And so the proposal strikes at the First Amendment's heart. It's overly broad. It's chilling a bunch of speech that should not be chilled, and it violates the First Amendment even under the D.C. Circuit's flawed reasoning. And so Trump's defense team, in giving Jack Smith the old legal backhand, they say this court should reject the efforts by Jack's office to use the law to modify the gag order to limit the leading candidate in 2024 from speaking. And so this modification should be swiftly rejected. Signed here by Todd Blanche, Christopher Keese. They're representing Trump in the classified documents case in Florida. And we're going to see what Judge Cannon does with this. Of course, this will land on her desk, and Trump's defense will be awaiting Jack Smith's reply, and it will be curious to see what he says and how Judge Cannon will rule. Now, Trump has a lot of additional support on this. So in our next segment, if you enjoyed this one, then we're going to talk about 24 states who are now also jumping in to help the president. They're saying this is ridiculous. He cannot be gagged because we have an election coming up and our citizens in our states need to hear from the president, you know, because he's running for president. We want to vote. And so coming up in our next segment, if you like this video, thanks for subscribing. Thanks for actually liking this video, and we'll see you there on our next segment.